Harvey Peyton, who served as our legal analyst throughout the trial, was in the courtroom and joins us this morning. Harvey, good morning. Were you surprised?
No.
You were not surprised. They didn't call a single witness.
No.
Why?
Well, I mean, the government's either proven a case against Mr. Blankenship or it hasn't. At this point, I think every observer who's been in the courtroom, particularly all the observers from the legal profession, see this as almost tit for tat. It's a tie. And the defense wins all ties in criminal prosecution. If you undertake to present a defense, number one, you legitimize the government's case by telling the jury it's something that needs to be responded to. Number two, you run the risk that you'll put on a witness, very helpful to the defense, but on cross-examination, actually interjects information that may help the state solidify their case, which is what happened to the state, of course, during their case in chief. So I thought it was a predictable move. Last week, we sort of started seeing things move this way with the insistence of the defense that the judge rule on certain tapes. The defense could have placed those tapes into evidence with their own witness, but they wanted to do it through cross-examination so that the government would then rest with that as a part of the government's case. This morning, the judge denied the opportunity for the defense to cross-examine the FBI agent with these tapes, gave the defense the option of putting the tapes in evidence in their own case. And you could just sort of see things start to devolve this morning. It's, well, Your Honor, has the defense rested, or has the government rested? When is the government, because the act of resting your case is a term of art. It closes off the case, and it's done in front of the jury, and at the time that's done, then the defendant has been put in all the jeopardy the government can put them in. And then there was a request by Mr. Taylor, said, Your Honor, after that, after it rests, we'd like to take a conference at the bench before we consider calling a witness. And you can sort of see things zeroing in on, they rest. They're going to tell the. Go ahead.
Well, Harvey Peyton's with us, who's in the courtroom this morning when the defense rested. Okay, I defer to you guys. I defer to the lawyers, but I've covered a lot of trials, and usually, I mean, almost always the defense will have a couple of people they'll want to put up there and go, well, this guy is going to say, I say guy in a generic sense, is going to help us convince the jury that. And so does that mean that the defense doesn't have anybody, or they feel like they've really sort of set their case through cross-examination of prosecution witnesses?
I think the latter is the truth. I mean, the defendant counsel had one of the state's witnesses, the alleged co-conspirator, Chris Blanchard, on the witness stand under cross-examination for 5 days. And as we talked about at the time, Hoppy, there's not a question that was asked Mr. Blanchard, nor an answer that was elicited, nor a document that the defense gave him to look at on cross-examination that wouldn't have been elicited in the same way with the same answer if Don Blankenship had been on the stand. He was the alter ego. The defense, do not believe the government has made a case based upon which this jury will convict their client. They also believe they've got error in the case that'll end up in a reversal.
Oh, really?
Do. Oh, yeah.
What's the error?
Well, I mean, restrictions on cross-examination.
The tapes not getting in, those kinds of things.
Tapes not getting in, the use of government documents, the selective use of tapes and memos, any number of things. And it started from the very beginning. I mean, as soon as the indictment was returned, the defense is engaged in meticulous motion practice.
Let me ask you about this, Harvey. Is that obviously Blankenship has a really good defense team. Obviously, he has the means to maintain a really good defense team. So let's say, for the sake of discussion, the jury convicts him. They appeal. I mean, you can, and you keep your defendant out of jail while the appeal is ongoing. I mean, if you have a good defense team and a well-funded defense team, can't you keep this thing going for a long time?
Well, certainly. I mean, if Mr. Blankenship is convicted tomorrow or the next day, and I don't think it'll go much past Thursday, if that long. If he's convicted, he has an automatic right to appeal his case to the Fourth Circuit Court of Appeals, and there's a direct appeal from there if the court chooses to accept it to the United States Supreme Court. So we're on a 12 to 18 month time frame there, and if the case is reversed and sent back, then the government has to decide whether to retry the case. If the case is sent back with an affirmed conviction, the man's entitled to a pre-sentence evaluation by adult probation.
So there's a lot of things that the thing could go on for a long time.
2 years from now.
2 years.
Sure.
Okay. Harvey Peyton's with us, serving as a legal advisor on this Blankenship case, where the defense rested today. I mean, the prosecution rested, which was going to be the story. Then the defense rested minutes later without calling a single witness. So do you well, now we get to the instruction part, and this is not a sexy part, but to me, Harvey, this is a really, really important part, because the attorneys for both sides say what they want in there, and this is really the charge to the jury. If you believe this, then this.
Right.
If you believe this, then this. If you believe this, you have to do this. So this is a really, without getting into too much detail, this is a really critical part, isn't it?
It is really critical, because, particularly when you've got a circumstantial evidence case on all 3 counts, as we have here. You know, last week there was a question from a juror to the court about what are the charges. You know, this afternoon at 1 o'clock, the lawyers and the judge are going over what's called the charge. That is what the judge will tell the jury. And in federal court, unlike state court, in state court the instructions of the law are read first, and then the attorneys argue the case. In federal court, the attorneys will present their closing arguments. The United States will go first. There'll be a reply by the defense. Then the government closes out. Mm-hmm. Then the court reads the jury the instructions, and that tells the jury, I mean, they are wondering. They have to be wondering after listening.
Yeah, what are we supposed to do?
Yeah, what are we supposed to do, and what are we looking for?
Can they take those instructions in the jury room?
Yeah, they get them.
Okay,
they'll get the written charge.
All right,
sure.
And during deliberations, they can come back and ask questions.
Well, on a limited basis.
On a limited basis,
right,
okay.
On a limited basis. They can't really ask about singling out testimony. They generally can't ask to have only a part of one witness's testimony read, or of course, they'll have all the exhibits. Yeah. All of the exhibits that were introduced in the case will be in the jury room with the jury.
Harvey, do you believe that the defense resting without calling a witness, which you say doesn't surprise you, do you believe that indicates that the defense does that indicate simply good strategy or a high level of confidence by the defense?
Well, I think it's both. I mean, you've got experienced defense counsel here who is bold enough and has the authority to tell his client, this is what we're going to do, and carry through with it. And they have confidence in the weakness of the government's case. Maybe they're right. I mean, the outcomes, if the jury thinks there's a case made against Mr. Blankenship at this point, all right, if there are people on this jury who are leaders who think a case has been made at this point, the defense wasn't going to do itself any good by legitimizing that, by putting on their own case, because they don't have anything more than the government had. Mm-hmm. You know, they've got memos and phone calls that say something different than what the government offered. But if a jury has made up its mind that there's a case, there's a high probability of a conviction.
Do you have a lean today on which way it will go, or do you want to hear what the instructions are?
I want to hear what the instructions are. I mean, I think the fact that the defense rested, that's a really good move. I mean, that's a good psychological move, too. You just look at the jury and say, you know, ladies and gentlemen, because the judge will instruct the jury first off that Mr. Blankenship is presumed innocent, right, and that's more than a legal presumption. It's a fact, and the government, before they can convict him, has to offer enough evidence, number one, to overcome the presumption.
Yeah, it's a high hurdle.
High hurdle, and that the presumption of innocence in and of itself, disregarding all other testimony, is sufficient for them to return a verdict of not guilty. Now, that's pretty powerful when it comes from a judge, and the defense says, we don't see it. We just don't see it.